How do you prepare your clients for trial?
I think some of the preparation for trial can take place right at the very beginning. But among other things, what I do is as early on in the process as possible where I perceive that it's likely that it's going to become a contested case and march down the road to a trial. I give my client what I term factor charts and questionnaires that they need to fill out. And what they are is I just start from the statute itself. So in New York State, the statute has a bunch of different factors on asset distribution, on maintenance, and on child support. I think the equitable distribution statute is up to 16 factors as of early 2023. The maintenance factors are 15. The child support factors are 13. So there's a lot of different factors that have to be considered, some of which are overlapping. But what I do is I literally put each factor and then several lines below each factor. And I give it to my client in Word format. And I say, fill out a rough draft. Fill out whatever facts you think are relevant to that particular factor. Use as much space as you want. That's why it's in Word format. You can expand the amount of space that you want to and fill up an entire page if you want to. And so what I have them do is fill out the rough drafts of those factor charts, return them to me, and then schedule an appointment. And then we start going over that and we start analyzing, okay, on each and every factor, what evidence do we need to prove that particular factor in our favor? What evidence do we think the other side is going to put in? And then what rebuttal evidence do we want to start gathering, in rebuttal to their case? So we start having that discussion as early on in the process as possible. So I'll provide that chart. If I haven't done so beforehand, I usually provide it right around the time of the preliminary conference. And at that point, you're approximately a year or so out from trial. And so that's really when your preparation should earnestly start, is right at that first conference with the judge, if not before. And then you start gathering the facts and the evidence. If there's a custody issue, I give my clients, it's a very, very lengthy questionnaire form. It's probably about a 30 or 40 page questionnaire form that they're going to fill out that provides me a lot of detail on what the facts are from their perspective on every conceivable issue that would come up with the judge. And likewise, there's custody factor charts. So I've, just the same as I do with the asset distribution and the maintenance distribution charts, I have custody factor charts that list out every conceivable factor that the court will take into consideration at the custody trial, and then spaces for the client to fill in facts that they think are in their favor, and then negative facts against the other side. So in other words, one factor is, alcohol or drug abuse. Hopefully my client's going to fill in the box that says, I don't have any such issues. But they're also going to fill in the box if they think the other side has those issues and why they believe that. What evidence do they think they have? If there's a contested custody issue as early on in the process as possible, I also provide my clients with what I term a timeline of events chart. So that is just a bullet point listing of every significant event that comes up in the parents and the children's lives. I have them fill that out historically, but then I want a running record of those events to be reported as the case is going along. And then aside from each event, again, it's in Word format, I have another column that says, what evidence do you have that corroborates that event? So Do you have text messages? Do you have emails? Do you have audios, videos, eyewitnesses, documents? What do you have, if anything, that we can enter that's going to corroborate that particular event? And then likewise, periodically throughout the case, especially if we're deeming it to be a case moving along towards trial, I'm going to want to touch base with my client and say, okay, where are you at in that timeline of events? Where are we at in terms of gathering the evidence that's going to corroborate those events? Do we need to start sending out subpoenas? What do we need to do to get that evidence in? And then you need to, as an attorney, keep track of, what evidence is coming in, and also make sure the other side gets it. Because you don't want to get to this stage of a trial, you haven't turned over discovery, and then all of a sudden the other side says, well, I'm going to object to the entry of that particular piece of evidence, wasn't turned over pre-trial, and maybe it's not quite in admissible form. And you don't want to take the chance that a judge is going to flip the proverbial judicial coin and say, I'm not going to let you put that in. So you want to make sure your ducks are in a row along those lines.